I think we are ready to go ahead and get started.
OFCCP has come out with an FAQ saying just that. It's like, look, we don't care how sophisticated these things are. You know, we're going to look for adverse impact, and then we're going to use the uniform guidelines to evaluate validity. So
I might sit. I don't know. All right. Can someone grab those doors back there as you, thank you. All right, well, good afternoon and welcome to Looking Under the Hood, running diagnostics for your selection program. I'm Amy Yost with DCI Consulting, and our intent today is to share some insights and recommendations around conducting third-party reviews of pre-employment selection and assessment programs, which may be done in the context of very formal compliance-driven audits on one end of the continuum, or as part of a more proactive, internally driven process improvement initiative, or any situation in between, really any situation calling for a systematic, independent, and objective evaluation. This isn't going to be a step-by-step tutorial. There's no one right way to go about these reviews, nor should you expect a really deep dive on validation or adverse impact methods or all of the legal issues surrounding selection and hiring. There are plenty of great PSYOP sessions that will cover those topics in a lot of detail. In fact, for a more comprehensive review of the legal landscape, I suggest that you check out Michelle and Julia's legal update session tomorrow afternoon. But we do have a robust conversation planned for today and a lot to get through in a really short amount of time. So I am going to ask folks to hold off on your questions until the end, and we'll open the floor then for some Q&A. What we will focus on are practical issues and challenges often faced by IOs participating in these types of reviews, whether that be as an external consultant who's brought in to conduct the evaluation, or as an internal practitioner supporting the review from the inside of the organization, or as an assessment developer whose products or platform may be the target of the review. So to that end, we've assembled a stellar panel of experts who have extensive third-party review experience and selection and assessment expertise, and who represent a range of roles and perspectives involved. I'm going to introduce our panelists really quickly. Name, rank, serial number. I'm sorry, you all deserve so much more. Honestly, if you don't know these folks, find out more about their impressive backgrounds, stalk them on LinkedIn, or better yet, chat them up here at the conference, because these really brief intros are not going to do them justice. And I learn something new from all of them every time we get together to talk about this stuff. And I'm not going to go in order of how you're sitting, so if you can give a little wave, give a little wave. I'm going to start with Julia Bayless, who is Vice President of Solution Delivery with APT Metrics and has a wealth of experience as an external and internal consultant across a variety of industries, and I have it on very good authority that she's also one of the best bosses an IO psychologist could ever hope for. Next to Julia, and representing the legal perspective today, is Michelle Duncan, who's an attorney and principal with Jackson Lewis. She also spent 14 years as a trial attorney with the Department of Labor, where she basically served as the OFCCP's counsel. She's a valued expert and legal partner, and if you ever want the inside scoop on anything related to the OFCCP, Michelle is your go-to. Joan Pappenchak is director of DCI's litigation support practice and has served as an expert witness for many class action discrimination cases. Joan also happens to be the funnest and most supportive grad school friend on the planet. Andy Solomonson is the general manager of global talent and assessment strategy at Delta Airlines, so he's representing the internal perspective. And I hope I don't embarrass Andy too much by adding that before becoming Dr. Andy Solomonson, he may have been the most talented, outstanding undergrad psych student ever to walk the hallowed halls of the University of South Florida. Or maybe I should say the hallowed palm tree-lined sidewalks. Last but certainly not least, we have Eric Seidel joining us. He's the Executive Vice President of Innovation at Modern Hire, where he oversees all research and product innovation initiatives, managing a team of IOs and data scientists. Eric also wins the PsyOp Oscar for the best use of an adorable toddler in a supporting role in a LinkedIn post. Seriously, you should check it out. It's really cute, and you will learn more about Eric's latest book. So just a bit of context before jumping in. So why this topic and why now? We thought this topic could be particularly relevant for PsyOp members now, given some trends that we've seen over the past few years. In the consulting space, we've definitely seen a significant uptick in client requests or prospective client requests for third-party review services, whether driven by increased legislative activity around recruitment and hiring practices, often focused on AI tools, or increased employer investment in workplace DE&I issues, perhaps influenced by Me Too, Black Lives Matter, and other social justice movements, or just by general mainstream media interest, certainly in artificial intelligence, but also in the use of just more traditional assessments in employment settings, an example being 2021's Persona documentary. This increased awareness and in some cases scrutiny of assessment practices coming from all these factions, has prompted more organizations to undertake formal reviews of this kind. Now, as IO psychologists, our work has always been at the center of the debates around how to best design, use, and evaluate assessments in the hiring process. This increased demand for transparency and accountability, advances in measurement capabilities and technologies, along with our ever-present and continued focus on assessment science, professional best practices, fairness, and managing legal risk, create a great substantial opportunity for IO psychologists to influence the direction of these program reviews in what is an ever increasingly complex and high stakes field. So when and why are third-party reviews likely to be done? You know, in preparing for this session, we all talked quite a bit about specific situations that can necessitate third-party reviews, ranging from really reactive scenarios involving legal or compliance actions where the review is required as part of a settlement or a regulatory audit, for example, to situations that prompt employers to more proactively request or commission reviews. And some quick examples of what we talked about were, you know, maybe as part of a broader initiative to look into the DE&I practices across the organization, or maybe a new leader comes in and requests a review of all of the processes in place within their new organization as part of that transition. Employers might evaluate processes as part of a merger or acquisition, integration or decision. Internal counsel may suggest a closer look at a new selection tool, perhaps, prior to it being implemented. Or, and this one came up a lot as we were talking, after something has already been put in place and is already being used by hiring managers. Another fun one, and I think this was one of Joan's favorites, was when the employer has started down a path of reviewing or auditing its own practices, doing it on their own, and then find something that concerns them, and then brings in a third party to help fix it. But we probably delved into, I don't know, a dozen, 15, 20 maybe, potential scenarios all along this continuum. And even though each one of them comes with really unique and interesting nuances and challenges, that would keep us here all day. And so we looked for common themes across all of these different scenarios and situations. And in the interest of time, we settled on 2 scenarios that we'll use as a framework for sharing insights and learnings that we hope will be helpful and get the dialogue started or keep it going among practitioners and researchers in this area. So with that, I'm going to tee up the first scenario and get the ball rolling. Please keep in mind that these are hypothetical and they don't reflect any specific clients or organizations that any of the panelists have worked with or are working with. All right, so scenario number 1 is a new law requires an employer to conduct an objective third-party audit based on its use of a certain type of assessment tool. Now, while this isn't specific to the New York City law recently passed regarding the use of automated employment decision tools, certainly that's a real and very timely example and poses a lot of interesting questions for us, right? So, Michelle, I'm wondering, would you like to kick things off and just talk about some of the recent developments or even trends that you see on the horizon that, from a legal perspective might impact this type of a review or one's approach?
Absolutely. All right. I love the booming audio. It really highlights all the important things we're about to share here. So, as the only lawyer on the panel, I'm going to give you a nice overview of some of the laws related to the use of AI in selection. It's a pretty short list for now, but we do have to talk about the New York City law. And when we were thinking about this panel, it was hypothetical. But then New York City went and passed a law that required the exact hypothetical situation that we were discussing. And so starting in 2023, it is unlawful for an employer to use an automated employment selection tool in New York City unless there is an independent, so impartial bias audit that's conducted. The shelf life of that bias audit is a year, so each year the employer would have to reevaluate the use of the tool. And the real kicker for employers is the results of that bias audit must be published on their website. And so this is, a really great example of the transparency, and I know Joan's going to talk about this too, that lawmakers want to require of vendors and employers in this space. So the New York City law leaves a lot to the interpretation of employers and lawyers. It does very broadly define an automated employment selection tool to include things that involve machine learning, data computations, artificial intelligence, which, by the way, does anyone have a good definition of artificial intelligence? If so, please let me know. So it's incredibly broad. This is really one of the most comprehensive to date laws requiring a proactive analysis of a tool and publication of results of that analysis before an employer can use it. Now, if any of you are from California, California may just best New York City. There is a current law pending there that I believe was just recently, the proposed law was recently amended, tweaked a bit, but that would require a much heavier lift for employers. So if you're in New York City, please be aware of this. Be on the watch out for what develops in California. And then don't forget about the first 2 states that passed laws related to AI, neither which requires an actual proactive audit, but the state of Illinois has a very sort of specific law related to the use of AI in video recorded interviews. And then the state of Maryland also requires notice and consent to applicants if facial recognition will be used during the interview stage. So just to kind of sum it all up, we're starting to see local and state laws grow up in this area, only one of which so far has an audit requirement. And so you may say, great, I guess we're good on the federal level then. We don't have to do anything there, right? Well, that's not the right answer, because what the enforcement agencies, primarily OFCCP, our friends at the US Department of Labor, and EEOC are doing is they are studying this issue internally, but until they come to a conclusion on best practices or guidance for employers, they're going to evaluate these tools using the already existing legal frameworks of Title VII, and of the Uniform Guidelines on Employee Selection Procedures. So, you know, we all know those were passed in the 70s, which for some of us doesn't feel like that long ago, but for others, I get that may seem very historical in nature, but those are the guidelines and really the rule of law if you're an OFCCP regulated federal contractor or subcontractor. So with that,
Great.
That's the legal foundation at this point, Amy.
Well, thank you. Joan or Eric, anything to add from the IO or assessment perspective with regard to this type of review?
Yes, as an IO psychologist, she scares me a lot. And I think all of us should be a little bit, right, on edge, because to me what we're seeing is legislation that's trying to catch up with understanding the use of artificial intelligence. And so what's happening is you're seeing, I believe, a lot of things being thrown against the wall to see what sticks. But I think that the motivation for it is likely that a whole bunch of stuff is going on in artificial intelligence, and regulatory agencies don't understand it, and local jurisdictions don't understand it, so they're all trying to, get to the bottom of what's going on. I think the themes that I believe are going to be most likely paths to addressing this are transparency and job relatedness. And so to start with transparency, again, I think that as psychologists, any kind of test, we try to control access to the content and access to the secret sauce, but more so with those that are based on artificial intelligence. And I think as a lot of IO psychologists believe, well, it's okay, they're doing it right, we can trust it, and now there are others who don't, but I think now we're finding out, well, it doesn't matter if we trust or not, we all are going to find out what's really going on. So this leads me to the second sort of component, or continue with transparency, that's what they want to know. They want to know what's going on, and they want to know how it's working in ways that I don't think anybody anticipated up until this point. I think vendors have been in a pretty comfortable role to say, we don't open the black box, but these kinds of legislative activities are causing that paradigm to go away. So in terms of job relatedness, Michelle, I think, takes my words. It is the Uniform Guidelines on Employee Selection Procedures, old, but they're the go-tos. And, in litigation, as experts, that's what we talk about when we talk about selection tests that are being challenged. What do the uniform guidelines say? What do the SIOP principles say? What do the APA standards say? What does current scientific literature say? And I think that all of those pieces have to be pulled together in order to respond to these kinds of requirements now in these jurisdictions. So to me, when I look at some of the requirements of these laws, they're talking about reporting. So again, I don't know how many of us as industrial psychologists are going to be hearing from attorneys. We can't do that, right? We can't put on our website what the result of our bias audit was. Well, you're going to have to. And so I think that that is something that makes us uncomfortable, and I think it's basically going to require a shift in thinking in order to be able to be responsive to these different laws. The other thing is, how do we prepare, right? Because there are so many things that are bubbling up in these different laws. And do you prepare for one? Do you try to prepare for all? You know, what exactly is the path forward? But I think it's something that, again, with, you know, internal and external counsel, it's going to have to be worked through to come up with that process. I think that's it for now, except I do think the job relatedness, and I think what the job relatedness looks like is, what are the characteristics that are being measured by tests that are reliant on AI? Do those characteristics change across time? But the bottom line from the uniform guidelines perspective is, you need to link the characteristics that these tests are measuring to characteristics that are important on the job. And the way I think about it a little bit is, when we first, maybe none of you remember this, but when we first started using Big Five, our job analysis approach back then never envisioned that we were going to ask about things like conscientiousness and neuroticism and, you know, all of those things. And we had to figure out how to amend our job analysis approach to be able to support the use of those kinds of assessments in selection procedures. So I think that, again, back then, we were all a little nervous about what do we put in a job analysis. I think we're going to be revisiting that when we're talking about use of artificial intelligence in testing.
Eric, anything to add from a data science and technology perspective? Uh-oh.
I'd like to add some length to this microphone cable. All right.
There you go.
Yeah, so I'll speak to this a little bit just from more of a data science perspective, I think. I mean, I'm an IO, sort of. I don't know what I am anymore, but I manage a team of data scientists, and so we think a lot about how we can make sense of data and how we can use it in the hiring process to benefit our clients and their candidates. And I think that what's really interesting to me is how IOs approach this and how the traditional HR world approaches these things versus how data scientists approach these things. So, you know, we solved all this in 1978, right? We put together these uniform guidelines that basically tell us what to do. It's fine, you know. We write technical reports, which everybody learned how to do in graduate school, that look at the different types of validity and maybe justify an assessment from construct, content, criterion related, whatever you want, right? You can write a technical report that justifies a test based on, let's say, construct validity, and you can do that 10 years ago, put the manual on the shelf, and keep using the test in perpetuity, in theory, right? So you've justified the whole thing based on sort of theoretical grounds. You know, and data scientists don't approach things that way at all. There's no theory. There's no theory with data science. It's not even a science in the sense that psychology is a science. And so a data scientist takes a bunch of data, puts it in a hopper, and runs a bunch of advanced, you know, machine learning algorithms or whatever to figure out what it all means and what it predicts. It's very powerful. It's very powerful because data scientists can use those techniques on unstructured information that traditionally we couldn't study very well as psychologists. So, you know, you could do video, you can do pictures, you can do audio, you know, free-form text, everything like that can now be studied with these techniques in a very powerful way and sort of quantify them so we can understand, you know, what they predict in a much better way. And so you have these two worlds colliding now, and I think all this raft of new legislation from all these cities and states and governments is all coming at it from the perspective of the data science perspective. They're not building on the uniform guidelines. They're coming at it from a completely different, mentality altogether. Ultimately, I like that mentality quite a bit. You might think as a vendor, well, I don't like the idea of being forced to be that transparent, and put the results of everything on our website and undergo annual bias audits and all these types of things. But the truth is I like it. I mean, as a psychologist, I like it. Why not? Why not have that level of transparency? Why not work towards that? And I know all these laws are quite confusing now, and they're different. They don't always match up very well, but in spirit and in theory, I like what they're trying to do. Because I think there's a lot of obfuscation that sort of goes on and can go on, in the algorithmic world. It's very easy to have black box algorithms that are built on who knows what data and all these things. So I think it's important. I think ultimately what's going to happen, though, is I think that this sort of data science mentality and the requirements for things like audits and things like, I think that's going to increase. I think that's going to win out over the traditional approach that we've had where you could write a test manual and put it on a shelf. And I think that's good. I think that's appropriate, and I think that we're going to have to work towards figuring out how to handle that and what to do with it. But, I mean, fundamentally, I like it. So I think that's it for now.
That's great. And I'm curious, do you have any other thoughts about, what's in it for the assessment vendors involved in these kind of reviews? So aside from the compliance aspect, you've touched on some other benefits or kind of positives of these requirements, but I, invite any of the other panelists to chime in on, other kind of upsides from the vendor's perspective of being involved in these.
Well, should I?
Go ahead,
Yeah.
yes.
I mean, as the vendor, yeah.
Yeah.
We try very hard. We've got about 50 psychologists and data scientists. We try very hard to do things the right way, and we're trying to be as rigorous and above board as we can. And so, I don't know that every firm approaches things that way, and certainly the ones that are, not IO driven. I mean, a firm that approaches AI with a, sort of pure engineering perspective, there's none of the theory that goes into what we do. There's no linking competencies to job characteristics and things like that to make sure that there's any, rational reason to use those tools. So I think that, if we can have better guidelines that encourage more rigor, more transparency, and all these things, I think that's great. I mean, there's a lot of focus right now on, DE&I and obviously bias in assessments is the big thing. And you can solve bias, but then you can solve it with a tool that has no validity too. So then you've accomplished what exactly? I'm not sure. So there's a lot of things that have to be considered, and I think the more transparent our field's guidelines are and the laws and rules are, then that's going to be better for everybody.
Great. Anything to add here before we move on to scenario number 2? This has been a great conversation so far.
I guess I'd just like to give a little more detail on some of the things that are wrapped up in these. So reporting requirements. So the New York City law also requires that it be posted 10 days. And I think this is a particular issue for us to work with. You'll be given 10 days. Applicants will have to say if they wanted to not take an AI-based test, and they have to be given an alternative. And what the heck does an alternative look like? Because if, as we're talking, if we're not exactly sure what the characteristics are that are being measured, then how do we measure those characteristics in a different way? So I think that's going to force the issue of the characteristics and the need for underlying job analysis. And I do think that as this progresses, we are going to see more things that almost look draconian, like the California, some of the things that they have and what they're looking at now, which is give us the data, give us the materials it was trained on, tell us if there are any negative impacts, tell us why there are negative impacts. These are all kinds of things that we really haven't envisioned, and some of these not even in litigation. have we had to talk about these things? And so now it's sort of like a brave new world on what these look like. I think you start with what we've traditionally done as third-party reviews, of looking at the sample size and looking at how the data were collected and, look at the relationship between the test and the job or criterion validity. All of those things we have to look for, but now we have to dig down further on the tests, further than we would ever imagine than looking at just the psychometrics of a standard test. We now need to be able to have a pretty good understanding of what the algorithm is doing and how that's impacting the outcomes.
Yeah, and just one more point, Amy, this again from a lawyer's perspective, because this is new, and because it does require transparency both to applicants but also to regulators in terms of publishing the results of these, I would strongly encourage organizations to cloak the work in privilege until you know what the results are. You can always waive attorney-client privilege later in the game to make those results public. But until and unless you are comfortable with the results, don't create a cookie crumble trail for plaintiffs or for regulators to follow by not doing this work under attorney-client privilege. And I'm not saying that just because that is part of what I do. You can use your in-house attorney. If you carefully craft privilege protocols, in-house attorneys can serve the same role. So just think carefully about communication and how that's going to reflect not only on whether applicants will choose to want to continue to be considered for employment with an organization, but also how those results could create some pretty significant reputational harm for employers along the road. And I will say this, Eric, wonderful to hear from you, and if every vendor was like Eric, we would have a much easier row to hoe, right? Because we see a lot of folks in this space, frankly, probably in our exhibitor hall right now, folks who do not understand the legal risks related to not complying with the uniform guidelines, not doing an appropriate adverse impact analysis, and simply, not offering validation services for the tools that they are selling. And unfortunately, those are the folks that I get to try to educate about what should be done. So be on the lookout for that, and I would just encourage this community to really think carefully about what is required and how to be a good partner for those employers that you're working with when and if their selection procedures are ever challenged.
Great, thanks for that. I am going to tee up the second scenario, and that is an organization's board of directors has mandated an objective audit of the company's recruitment and selection policies and procedures after social media posts from both former and current employees citing gender and racial bias within the company have gone viral. So, Andy, can we start with you on this one? What are some key considerations in preparing for a third-party review in this kind of situation?
Yeah, absolutely. Thanks, Amy. So, in thinking about this as a consulting project, what would be some of the key scoping considerations here? I want to talk a little bit about what the key deliverables or outputs of this project might be. Who are some of the key stakeholders that you would need to be attuned to, and what are some of the key data sources that you'd use within the scope of this project? So, first of all, outputs or deliverables. I'd see multiple levels to this. So thinking about this particular situation, absolutely a detailed audit report would be a key deliverable, but I don't think the board would be satisfied with waiting, a few months for the technical report to be delivered while the third party is, doing all the analysis and the investigation. So I think another key deliverable in this instance would be a series of executive summary presentations
keeping the board and senior leaders apprised of the progress and providing key updates, and then certainly a final presentation to the board and senior leaders about the results and recommendations from the audit. And then I think unique to this particular scenario would be how to respond to the presenting issue, which was the social media post that went viral. There would have to be some sort of corporate level response to this. And I think the outcomes of the audit would really shape what the company's response could be. Could it be, discrediting the posts and providing the company's perspective, or if the posts were valid, what actions the company is taking from a DE&I strategy and action standpoint to address some of these issues that were found. And another point on the deliverables as well, I think, and Julia's going to talk a bit more about what frameworks that could be used in this type of scenario, but definitely a detailed review of what the company's doing well in terms of what was investigated, and more specifically, though, what the gaps or opportunities and key risk areas are, and perhaps a scorecard at some degree to show how the organization is actually doing in each of those areas reviewed in the audit. And then there would ideally be an extension of this that would show what are the key actions or recommendations coming out of the audit, and a prioritized list of recommendations. And and technically speaking, the audit would probably stop there and wouldn't necessarily carry through with taking actions. That could be a follow-on set of projects or project to carry out any of those actions that were agreed to. Okay, quickly talking about who the stakeholders would be. Obviously the board, because they've mandated the audit, and senior leadership would be closely involved. There would be the internal stakeholders within the company, certainly HR and talent acquisition, because this involves the selection and assessment systems, DE&I, that division of the company, and certainly legal and corporate communications or marketing, because there would be an external communication piece to this ultimately. And then those would be your direct consumers, but then you would have your other stakeholders, including the group of candidates where the apparent bias occurred, and then finally the general public, because this is a social media post that went viral, and they're consumers of the company and potential applicants in the future as well. So you kind of have to manage that brand and reputation as well. Then finally, from the data source standpoint, I'd see it as both qualitative and quantitative in nature. Qualitative, you'd presumably do some detailed investigation of the actual issues cited in the social media post. You would probably do a broader social media review to see if there's any other corroborating information out there, or opposite information out there in social media. Then looking more internally, presumably do a series of interviews or focus groups with the internal stakeholders that I just mentioned, representing the key areas to see what is actually occurring from a practice standpoint. And then you would also look at the quantitative information. No surprise, you'd presumably conducted formal adverse impact analysis as a formal way of determining whether there's actual bias occurring. And then if you do identify bias in those situations, you would drill down and do more specific analyses to uncover the specific sources of bias as well. So that's a little bit about how we might scope this type of engagement.
Yeah, I think just to add to that just a little bit, thanks, Andy, I think
Couple things I might add there in terms of preparation and deliverables. Totally agree with kind of the incremental and ultimate deliverable approach. Like, what are the steps on the way that we're going to deliver in response to this? I think also with regard to stakeholders, really creating a map of your stakeholders. So completely agree. You've got your board, obviously they're the ones who are asking, we got to go after this. And then your internal employees, your candidate pool, your customer base, whatever the impact is to the business, but really mapping out and being strategic about what are the touch points for all of those stakeholders and how do you help to manage not just the communications, what's being delivered to those stakeholders, but the feedback loops that you need, and to adjust the scope and the planning as you go. So like, how are you helping those stakeholders along? How are you taking the input that you're getting from them and incorporating that as you adjust and align? And I think another piece on the stakeholders to think about is the need for alignment, a perhaps overused word, right? But the need for alignment of, okay, this is what we're going to go after, and this is how we're going to do it, and this is what we're prepared to deliver. Are we good? And getting the alignment that you need, and I'm going to use the phrase that I am liberally leveraging from former colleague Ted Hayes of beware fake alignment, right? Beware the head nod of just, yeah, sure, that's good, that's great, and it's not, and you find out about it another kind of way. And then I think just lastly, in a situation like this that can be really charged, when it's something that has been externally provoked, and you don't know what's real about it, and it's going to take a lot of heavy lifting to get there, is really creating that space to explore and define the scope and get comfortable with that, and just recognize that there's a lot in play and there's a lot that can be solved by this kind of third-party review and identifying the action items and prioritizing, and there are things that cannot be solved by these means. And so really being able to separate and manage those expectations, I think, is critical too.
And I know we talked about the potential situation where you're brought in or you're asked to look at this thing, so in this case selection and recruitment practices, but then along the way you start to hear about performance management or pay and compensation and other areas that aren't within the defined scope, but that could be really helpful information, right, for the organization.
Right. Yeah, absolutely. And that can be the yes and, or it can be the yes but not now, right?
Right.
Yeah, and with respect to deliverables, that project creep can really create a challenge for deliverables, because as the lawyer who is reading some of these findings and recommendations, if this is meant to be, if the objective is meant to be a pointed response to issues raised, it may be certainly beneficial to explore other recommendations that are being made, but I wouldn't want them reduced to writing in the report that is addressing the complaints. So it's a bit of like, project creep is great, but let's make sure we're really careful about the deliverable. And I know Joan and I worked years ago on a case that was in litigation, and what we did, and this is a framework that I've used for so many other projects, before Joan ever actually wrote a report, she would share with me over the phone kind of the headers, like, here's this section, and this is what we plan to say. Okay, good. Here's this section, and oh wait, no, we don't want that in the report. Or let's talk about that. Maybe we can frame that differently. It's just a matter of, once you create that record, it's very difficult to back away from. The second thing is, there is a bit of a slippery slope around public disclosure, and we see this with respect to pay equity, diversity, equity, and inclusion, and other things as well. We have a really sophisticated group of external stakeholders now, the people who are the consumers of these public disclosures. And gone are the days when we would say, we did a review and we're good, so don't worry. That's not going to, pass the sniff test with current stakeholders. And so be prepared for follow-on requests about, well, what did you review? What data did you use? Where are the results? What methodology was used in your analysis? And you have to really be conscious about knowing where the organization is going to draw the line in terms of the amount of disclosure. So those are my two thoughts, project creep and disclosure. Yes.
One other group that I'd mention as the stakeholders are the shareholders. So if you're publicly traded, your shareholders hear this kind of thing, they feel like their stock value may drop, they may come back and try to sue you. And so, you know, I saw a case recently where it was a sexual harassment was published and in a newspaper, and the shareholders said, well, you lied to us on the investor disclosure sheet because you said you're an equal, you know, employment opportunity company, and well, you can't be because there are all these complaints. So it's a weird position to be in if you're in HR or in IO consulting, to then be sort of pulled into dealing with the reactions of shareholders. And it's just one more thing to think about for, you know, the big companies that are publicly traded.
Great points. So frameworks have been mentioned a couple of times, and Julia, I know you have some ideas or thoughts to share about frameworks that might be helpful or useful in this type of work.
I do, and I'm mindful of our time. Who can believe it, right?
We do have a few minutes, so go right ahead.
All right, so this is where I start speaking faster. So thinking about frameworks, I think they're, you know, not necessarily new to the field, familiar frameworks that we use. I think one of my favorites these days blends from the design thinking world of discover first, lowercase d, discover. Discover first, and then, you know, design, pilot, iterate, all of that. But really, in a situation like this, figure out the ground truth, like what is going on. And this goes back to, Andy, what you were sharing too around sources of data, identifying ownership along the way too, like all of that is really important in that discovery phase to like truly understand what's going on, and then figure out like what is it that we need to do as a result of that, right? Like if we're defining our incremental and our ultimate goals in this scenario, does that discovery influence what that starts to look like? And then as we start to build toward those incremental deliverables, as we share our headers with Michelle over the phone, you know, like are we starting to see that creep in a direction that we actually want to pursue, or are we starting to see that creep in a direction that we want to further narrow? So really taking an iterative approach, I think, can be really valuable.
That's great. Andy, Julia, any other kind of practical tips or, you know, pitfalls or challenges to look out for?
I can start. So speaking as an internal IO and having an external party come in, and I can speak from experience because I've been in this situation, the advantage of that, first of all, is to avoid the appearance of bias. You know, you have, as an internal IO, you certainly have the capability to conduct this type of audit, but it's often valuable to have a third party come in and being able to work directly with them, but kind of staying out of the way at the same time so that you avoid the appearance, right or wrong, of potential impartiality. And then as an internal, though, you do have to strike that delicate balance because you are a key stakeholder as well, and you need to support the audit. You're probably facilitating it. You're a key subject matter expert in that situation too. So you're kind of playing multiple roles from that standpoint.
I think the only thing I'd add there is just clarity of ownership. There can be lots and lots and lots of chefs in this particular kitchen, and so how do you figure out who's the pastry chef, who's the sous chef, and who's doing what? And that's about as far as I can take the kitchen analogy, but really creating that clarity and revisiting it, right? Like as it progresses, like, oh, actually we are taking this on and you need to take this on and all of that kind of thing. And then super tactically, version control. Right, like what is it that's going out to whom and when, and do we have clear ownership of what that looks like, and is it stamped with the appropriate ACP?
That's great. Are there any particular ways that this type of consulting differs from from other consulting work that IOs are typically involved in, any special skills or knowledge that, outside of our traditional IO training that you think are particularly helpful?
I don't know if it's, this is Julia's opinion, right, of the world, but I don't know if it's a different set of skills, but I think adaptability and flexibility and hypervigilance are like key in scenarios like this, particularly those that are really highly charged. And I think too, like being able to maintain perspective, right? Like these things can feel like emergencies, right? But separating emergent from urgent and time sensitive, and like the ability to be thoughtful and produce what's really needed without getting kind of caught up in the need to get it out so fast that we make mistakes.
And I would just add that unlike say a typical job analysis, test development, validation project, there's not a real defined, very prescriptive approach and set of documentation requirements for this. So on the one hand, you do have a bit more flexibility in shaping the consulting approach and outputs to the particular business need, while staying true to our discipline and methodology as IOs who are consulting on this effort too. But I think that flexibility is really where the consulting and business savvy definitely comes in. So not a unique skill set, but part of being a consultant in this effort.
That's great. Anything else to add? Yeah, Joan?
I think one thing is that as IO psychologists, we always maintain the confidentiality of everything that we work on. We don't talk about clients to other clients or to other people. I think there's a heightened restriction in communication in this context, which, if it is going to get pulled into the legal arena, everyone should have from the very moment been careful about job memos and emails and notes from phone calls, all of those things that maybe all IOs haven't experienced if they haven't really sort of gotten deposed before or been dragged into litigation kicking and screaming. And so it's just one of those aha things that is helpful at the outset to say, nobody talks about this to anybody who's not in this room.
Great. Anything else? All right. In that case, I do want to leave some time for questions, but I'd like the panelists to leave us with some words of wisdom in kind of lightning round fashion. So if you had to leave our PSYOP audience with one key message or question that needs answering with regard to third-party reviews in 1 minute or less, what would that be? And we'll just start with Andy.
Okay. So I would say, first of all, be proactive about this audit type of activity, especially with the heightened sensitivity around these issues with the new legal context, et cetera. It's better to be prepared and know in advance what your risks are versus having to be put in a reactive and defensive position. And I would also say to any external consultants out there, I haven't commonly seen this as a marketed practice area, but I think it does happen often, whether you're invited in to do this type of work or not, and it can be somewhat lucrative because it can obviously lead to follow-on work depending on what the actions are.
Thanks. Julia?
Okay,
We're just going to go down the row.
All right. 1 minute or less. So I think just a couple things. There's no such thing as over-communication, right? So in circumstances like this, so communicating clearly and often and repeatedly, and also not hanging on to bad news, right? It can be really tempting to take something that's like, oof, we didn't expect to find that, and we did. Don't hang on to it. Provide good context for it, but don't hold on to it. And then again, just maintaining perspective, like setting the context for what comes next. I think sometimes in situations like this, if we're the ones who are living and breathing this work and we're in it up to our eyelashes, recognizing that sometimes our stakeholder groups or our audiences are not. And so like thinking about where they are and the last time you spoke with them, and how do you kind of bring them to where you need them to be to get the real alignment on the next steps.
All right. I think the key takeaway that I would want to give this group is to keep your eye on the objective of these projects, whether it is meant to comply with a new law, or it's a proactive analysis, or a proactive analysis that is being done in response to a hypo like the one that has been discussed. So keeping really good parameters on and a clear definition of what the objective is will really help in so many different ways. It will help in terms of what the deliverable will ultimately be. It will help with time management so that the employer isn't sending an outside consultant down a bunch of rabbit holes because they're interested in looking at lots of different things, not just the one particular predefined objective. And with respect to these laws, and as we have to think about the report out, whether it is an impartial bias analysis or bias audit under the New York City law, or whether it's data that's being produced to the state of Illinois under the newly amended AI in interview, the Video Interview Act law, we want to just make sure that we're thoughtful about how we conduct the analyses and what the objective of those analyses are. Because we're going to be dealing with, unfortunately here, kind of a patchwork of legal obligations in this area where local and state laws are not always going to align, and none of them may necessarily align with what the federal enforcement agencies end up doing.
One thing that I offer as a takeaway is that the employers who are using tests that may be vendor tests are going to have to be much more curious about what's going on. I think in many cases, as IOs, if we get sort of these reports and they seem to be very good, and we accept them at face value, I think now employers are going to have more of a dialogue with the vendors about exactly what's going on, because in some of these, it is the employer who is supposed to be establishing, the job relatedness of the test. So I think there's this desire for vendors to fix themselves, quote unquote, but really what's going to happen is that relationship between the employer and the vendor is going to have to be more strategic and more open than ever.
All right, quickly. I think that from my perspective, we're just in really interesting times right now where we have the traditional IO, HR, legal frameworks colliding with all this new stuff that comes from the data science world. And I think that both sides of that coin have a lot to learn from each other. I think that we can learn a lot from data science methods and the power of them to understand data in a much broader way. The kind of continual analytics that tends to go on in the data science world and things of that nature. At the same time, we as IOs have a huge opportunity to try to influence legislation, guidelines, et cetera, professional practice in the data science world, in the larger engineering world. We have cumulative knowledge to share and theory building to do, and a focus, I think, on humanity as well. And so in some ways, I think of IOs as the guardians of humanity, or at least we can be the guardians of humanity in this new data science, big data world, and put forth our values and some of what we learned in graduate school to help keep the focus on building tools that are good for actual humans.
Great. Well, I think guardians of humanity is a great concept to wrap up on. Thank you so much to our panelists today. It has been a great discussion. I know we have gone over. There is a break going on right now. So if folks want to stick around for just a couple minutes and ask questions, I do think that we have the room for a little while longer. So I'm going to go ahead and invite any questions from the floor at this point. Yes. There's a mic there so that we can all hear you. Thank you very much.
Have theories. Data science may be built without clear theories. theories of mind, but there is a theory embedded which has not been uncovered. So I really like that last comment that said discovering or building theories. So it would seem to me that there's a validation strategy locked in the data science information. So if it does predictions, there are reasons for it, and if there are reasons for it and a method of collecting the information, you got a foundation for a theory and for a defense.
I'm not sure that I was able to hear that question well enough.
I wasn't either.
I'm sorry, the echo made it really hard to.
You couldn't hear it? Can you hear this?
Yes.
The question I have is there not a theory in data science that could be used to develop evidence for validity?
Theories from data science that could be used as evidence for validity.
Yes.
Thank you.
Well, I can give a non-answer, I guess. I don't know. I mean, data science to me is not a science in the sense that it's, not theory-based. It's the science of studying data, not the science of studying people or, building models of what human competencies relate to what job performance aspects. So, I mean, to me, data science is very powerful at understanding data and can predict things, predict outcomes very well potentially, and potentially do so in a fair way and all those things. But in terms of, understanding how and why it's doing that, I don't know. I think data science works backwards from traditional I/O, where we build theories and we test the theory, build hypotheses, test hypotheses with data, refine them, publish about it, et cetera, build this cumulative knowledge base, whereas data science just like throw everything in there, see what predicts. But then you have an opportunity to look back and try to figure out what's going on in the black box. It's almost like the reverse type of process, and that's what needs to happen, I think, with a lot of the bigger data science initiatives.
Yeah,
Any other questions?
I had one follow-up to that, Eric, and this really is a sort of a colliding of two worlds, and it's interesting to me because when I speak with folks who are experts in machine learning, who have degrees in machine learning, and I talk to them about like correlation coefficients for the variables that are going into the algorithm, they're just like, how old are you? Like, get with the innovation here, because the reality is those tests that we would typically use to evaluate like the strength of a regression model don't apply in the same way to machine learning. And so we're in a situation where, I say, okay, I've got a lot to learn, but here's the important thing to remember. I probably know more about this than the enforcement agencies and the investigators. If you can't explain this to me in a way that I can understand, how will employers ever be able to get through an audit without an enforcement agency believing that they're hiding the ball and not really sharing critical information to understand how a tool works? So until we advance to that level, and when I say we, I mean all of us in terms of the enforcement agencies and others, we're going to continue to have this push-pull, I think, between traditional legal and IO psychology concepts and machine learning and data science.
Yeah, my question actually, I posted it online too. It really follows up from that. The explainability is not binary, right? Like there's different levels of it. A multiple regression is more difficult to explain than a regression with only one variable. And radial basis functions become really hard to explain. And then you get to things that can really only be explained by analogy. Like the reasons for decisions that neural networks can make when they're sufficiently deep. So what is going, what is going to be the acceptability of the boundaries when it comes to how explainable something is, or what kinds of explanations will be acceptable?
Yeah, I mean, I think there's a bit of an unknown there, but I'll tell you what I'm doing with clients. I want to understand what features are being included in these big data algorithms. So what features of applicants are being evaluated. And that's actually something that we're required to do under the state of Illinois law, and also in other places where we have to explain, New York City, explain what characteristics are being evaluated by AI. But I'm doing the legal framework, and some of this we're kind of making it up as we go, unfortunately, but I just say, like, this has to make sense on a visceral, gut reaction level, and we're calling it kind of like face validity. So show me the features that you're pulling from an application or the features that you're evaluating during an interview, and let's just see, whether on their face they make sense in terms of being job related. Or in terms of the outcome that we're trying to predict. So does this relate to performance? Does this relate to retention? And where things don't have a sort of face validity, then we're thinking through what are the right types of analyses, whether it's like the ROC analysis or an MAE type analysis. What are the analyses that experts in machine learning are using outside of the employment context, and can we borrow that and use that here, even though the enforcement agencies don't know what ROC or MAE is, and I'm learning it too. So, there's going to be risk until we have good, clear guidelines, which I think could happen, right? We've got some folks here that are part of an initiative by the Institute for Workplace Equality. It's a technical advisory committee that is on the use of AI in hiring. And it's led by former EEOC Commissioner Vicki Lipnick. So we've got a great set of stakeholders: legal, data science, machine learning, vendors, employee advocates, applicant advocates. So we're hoping that, and we're in the throes of evaluating like some survey response data from all the stakeholders. We hope to be able to publish some guidance on that soon. And EEOC and OFCCP are sort of doing the same in their hire initiative. So hopefully we'll have some guidance for employers.
Thank you so much. Oh, got one. I guess we have time for another question. There's not.
My apologies, and for keeping everybody. So my question is about the broadness of this law in New York. So if you take it at face value, and I read it plainly, I'm thinking, well, wouldn't anything that just is computed as a score and has a decision be an automated decision rule? So a job knowledge test, a civil service exam done by the state of New York, a civil service exam done, created by the city of New York. It really kind of, it's a slippery slope to anything that a person isn't looking at and reading. And that seems a little impractical. I mean, are you going to get your state civil service board posting their keys after every exam that's going on? There could be hundreds or, that are happening. So, I mean, what are your thoughts on that?
Yeah, and I know, Joan, you've been following this very closely too, but so my read is there may be a bit of a sort of way to avoid falling within the New York City law by the language that's included that says an automated employment selection tool must substantially assist in the decision making. And so if, for example, you have a tool and it's a standalone, high stakes, pass fail, I think certainly that substantially assists. But many employers that I'm working with are thinking about now using the scores from tools that they're using in a more holistic way, and saying, so it's like this may inform decisions about who will move on to the next step, but it's not definitive, and for that reason it doesn't substantially assist in the decision-making process. So it may be that, but I agree, your read of the law is that it is meant to be incredibly broad. In fact, some of the exceptions were laughable. They were like a firewall is not an automated employment selection tool, okay? So it's very, very broad. But it's only for hiring and promotion, so just keep that in mind. It doesn't have anything to do with pay. And it's only for positions that are filled in New York City. And then the notice requirement is even more limited. The notice requirement is only owed to New York City residents who are applying for jobs in the city. So we've got some, things that we'll need to see how the law is actually enforced, but the language itself gives us a little bit of room to interpret what the meaning is and how broad it will be. Not comforting. I hear you.
Right. Well, thank you all for staying 20 extra minutes. We lucked out that the break was scheduled after this session. And thanks again to our panelists.